In 1857, the highest court in America ruled that an entire race of people had, in its words, no rights which the white man was bound to respect. Not fewer rights. None. The court believed this decision would settle the question of slavery for good. Instead, it helped push the country into civil war. And 11 years later, a single amendment was written for one purpose: to erase it completely. This is the story of Dred Scott. Dred Scott was an enslaved black man in Missouri. For most of his life, the law treated him as property, not a person. But Scott had lived somewhere the law was different. The man who enslaved him, an army surgeon named John Emerson, had carried Scott across the country on his postings. From 1834 to 1836, they lived in Rock Island, Illinois. Illinois was a free state. Then, for 2 more years, they lived at Fort Snelling in the Wisconsin Territory. Under a law called the Missouri Compromise, slavery was banned there too. For years, Dred Scott had lived on free soil. In 1846, Dred Scott and his wife Harriet walked into the St. Louis Circuit Court and sued for their freedom. Their argument was simple, and it rested on a principle Missouri courts had honored for decades. Once free, always free. If a person had been made free by living on free soil, that freedom did not disappear when they crossed back into a slave state. For Dred and Harriet, the stakes were as concrete as it gets. A ruling in their favor was the difference between owning their own lives and being sold away from each other. They had children. A win freed a whole family. The case would take 11 years. By the time the case climbed to the Supreme Court, the man listed as the defendant was John Sandford, the brother of Emerson's widow. A clerk misspelled his name in the official record, adding an extra letter, and so the worst decision in the court's history carries a typo in its title to this day: Dred Scott versus Sandford. The country around the case was coming apart. Slavery was tearing the nation in two, and the men on the Supreme Court believed they could end the argument. They believed a ruling from the highest court in the land would force the country to accept a final answer. They were about to be catastrophically wrong. On March 6, 1857, Chief Justice Roger Taney read the decision aloud from the bench. The court had ruled 7-2 against Dred Scott. And the ruling did not stop at Dred Scott. It came in 3 parts, and each one was worse than the last. First, the court ruled that black people, whether enslaved or free, were not citizens of the United States. They never had been. They never could be. And because they were not citizens, they had no right to sue in a federal court at all. By this logic, Dred Scott had no standing to even bring his case. Second, the court ruled that living on free soil had never made Scott free. His years in Illinois and the Wisconsin Territory meant nothing. And third, the court ruled that the Missouri Compromise itself was unconstitutional. Congress, it said, had no power to ban slavery in any federal territory. A law that had held the fragile peace of the nation together for 37 years was struck down. It was only the second time in history the Supreme Court had struck down an act of Congress. The first time, in 1803, the court claimed that power to protect the Constitution. This time, it used that same power to protect slavery. In the majority opinion, Chief Justice Taney wrote that at the time the country was founded, black people had been regarded as so far inferior that they had, in his words, no rights which the white man was bound to respect. That sentence was not a description of the past. It was the law of the land, handed down by the highest court in America in 1857. For every free black American in the country, the message was total. Whatever you have built, whatever you have earned, whatever state you call home, this court says you are not one of us, and you never can be. 2 justices refused to sign on, John McLean of Ohio and Benjamin Curtis of Massachusetts. Curtis did something devastating. He went back to the founding itself, and he checked the record. And the record showed that Taney was simply wrong. At the time the Constitution was ratified, free black men had voted in several of the states, not as a technicality. As citizens, taking part in ratifying the very document Taney now claimed had always excluded them. In other words, black Americans had helped create the Constitution. Taney had rewritten history to erase them from it, and Curtis proved it on the page. Benjamin Curtis resigned from the Supreme Court within months. He could not serve on a court that had issued that ruling. The court had wanted to end the argument over slavery. Instead, it lit a fuse. The North was outraged. A decision meant to be final convinced millions of Americans that the slave states now controlled the Supreme Court itself, and that no free territory was safe. The ruling became a rallying cry. It sharpened the debates between Abraham Lincoln and Stephen Douglas. It helped carry Lincoln to the presidency. And it moved the nation, step by step, toward the Civil War. Legal scholars today still rank Dred Scott versus Sandford as among the worst decisions the Supreme Court has ever made. And Dred Scott himself? Just months after the decision that made his name infamous, the family that had originally owned him, the Blows, purchased Dred and Harriet and set them free. After 11 years in court, Dred Scott spent the last part of his life as a free man. It did not last long. Dred Scott died of tuberculosis in St. Louis in 1858, about a year and a half after the ruling. He never lived to see what his case would set in motion. The Supreme Court had said black Americans could never be citizens, that an act of Congress could not undo it. Taney believed he had settled the question permanently, beyond the reach of any ordinary law. There was only one way to erase a ruling like that, not a law: an amendment to the Constitution itself. In 1865, the 13th Amendment abolished slavery. And in 1868, the 14th Amendment opened with a single sentence written to destroy Taney's ruling at its root. All persons born or naturalized in the United States are citizens of the United States. That sentence had an author, a congressman named John Bingham. If that name sounds familiar, it should. He was the subject of the very first video on this channel. The man who wrote the words that erased the worst ruling in the court's history. The Supreme Court told Dred Scott he had no rights the law was bound to respect. It took a civil war and a rewriting of the Constitution to prove that court wrong. If this story stayed with you, like this video and subscribe. There are more of these than you would believe.